Sat Shri Akal, I'm Bhupinder and you're watching Jus Punjabi. Friends, whenever we're in a country that is not ours, or maybe we would say we immigrated here and we want to embrace this country, there are so many legal things that we need to take care of, and sometimes we don't know much about them. Well, in that case, we need good lawyers, good attorneys to help us in doing that. Right now in our studio, we have very worthy attorneys from Bretz and Cohen LLP, so let's meet them once again. Hello, Kerry, and hi, Eileen. How are you doing today?
Good, Bhupinder. How are you?
I'm great. Wow, you called me Bhupinder. I like that.
You like that better than BK?
Sometimes I do. It's like, you know, when you just think that, oh, my name is getting lost. So in that way, I prefer being called Bhupinder.
Get back to our roots.
Oh, yeah, definitely. Okay. Well, today we are going to talk about naturalization and if somebody has criminal background. So what options do they have? Let's start with a very common one. If somebody is caught driving while in intoxicated influence, what options do they have at the process of naturalization?
That's a really good question. I think maybe we should start with some of the basic requirements for naturalization first, and then go from the complications with having maybe driving while intoxicated or some other interesting history.
Yeah, in order to be eligible to naturalize, you have to show, one, that you're a lawful permanent resident. That lawful permanent residency you must have for at least 5 years. There is one exception. If you're married to a U.S. citizen for 3 years, you could do it earlier at the 3-year mark. You have to show good moral character for the required statutory period, which is either 3 or 5 years, depending on marriage to a U.S. citizen or not. You have to show that you have the required physical presence in the United States. For 5 years, you need to show you have 30 months in the United States. And during that period of time, you cannot be out of the United States for more than 12 months consecutively. And that's very important. If it's based upon 3 years, based upon marriage to a U.S. citizen, you only have to show 18 months in the United States. Again, you can't go past that 12-month mark in one trip outside the United States. Now, the good moral character, that's it's a pretty broad term. It's a broad stroke, but immigration looks at that to see, have you been arrested? Are you on probation? Have you been even in jail recently? And you know, it goes from there. But I'll let Mr. Bretz explain.
Basically, good moral character does not necessarily mean going to temple every week or being religious. But there are some things under the Immigration and Nationality Act that automatically disqualify somebody from demonstrating good moral character. So convictions for something called a crime involving moral turpitude, which are things like a theft offense, convictions for possession of a firearm, all kinds of criminal history will make you ineligible to demonstrate good moral character during the 5 years. Now, there are some convictions that don't make you automatically ineligible, but probably immigration could decide that you don't have good moral character. So, for example, very commonly people get arrested and charged with driving while under the influence of alcohol, sometimes called driving while intoxicated, or sometimes driving under the influence of narcotics. That will not make you automatically ineligible to demonstrate good moral character, but it will be a negative factor. In the New York district, generally as a rule, if you have any kind of criminal history, including something as small as disorderly conduct, they will not naturalize you if it occurred during the 5 years or the 3 years, depending upon whether or not you're married to a citizen. Additionally, if during that 5-year period you are on probation or you are on some kind of penalty for the criminal history that doesn't make you automatically ineligible, they're not going to naturalize you either. So it's very broad. Now, there are certain circumstances where immigration can go beyond the 5 years. So let's say someone had something very serious in the 80s, drug trafficking. Believe it or not, you can be naturalized with a drug trafficking conviction if it occurred before November of 1990. It's possible, but immigration would have to be satisfied that you've shown reform of character or rehabilitation. One other thing on good moral character, there are some things that do not require a conviction at all that would make you automatically ineligible to demonstrate good moral character. So, for example, adultery. So if you're at your naturalization interview and the examiner says, so how's your marriage? My marriage is fine. You've been married for 20 years. Yes. Did you ever cheat on your wife? Well, I did once 10 years ago, but we worked it out. Or I did once 5 years ago within the statutory period. That could make you ineligible. So there's a whole list. Good moral character is a very tricky issue, and one that if you have anything to worry about, you should definitely consult a lawyer.
And if you have if you have been involved in adultery or anything, will it always be a negative for you, or can you prove that, oh, there were some circumstances that it happened and we worked it out?
Yeah, I think that's a really good question. Well, if it occurred within the statutory period, I think it's going to make you ineligible. If it occurred before the statutory period, I don't think it's going to make much of a difference. I think also habitual drunkard is one of the grounds that would make you ineligible. So it doesn't require a DWI conviction. It doesn't require anything except some kind of evidence that you may be an alcoholic or a substance abuser. So those grounds are rare. They don't come up all the time. Mostly the criminal grounds come up. Another thing to worry about with naturalization is your earlier history with immigration. Some people get their green card and maybe weren't really eligible for it. Forgot to mention the first case they had with immigration in another name or something like that. When they go to naturalize, right now the investigation is much more intensive and much more sophisticated than when the green card application. And immigration will come back and revisit how you got your green card, if it was by marriage, from who, was there a previous marriage case. So anybody who's got any hidden secrets regarding how they got their residency really should consult counsel before considering naturalization.
Well, definitely.
Yeah, and something as plain as you were married before, you may not have gotten a legal divorce and then you remarried again, but you were married in your home country, never thought you needed a divorce and got married here. Immigration will look at that and say, oh, you weren't eligible for that marriage. They want to see the divorce, even if the reason for the underlying application for your green card wasn't through marriage. They may want to see that divorce and want to see that you're not a bigamist. So it really, it has long arms. A lot of these officers, they'll look back into every nook and cranny. So you really want to be careful.
Definitely. So if you're going for a naturalization and if you think there is something that you need to talk to a lawyer, definitely you can consult a attorney, and definitely you should consult an attorney. And what's better than going to Bretz & Cohen LLP? Well, we will talk more about other things, but we'll take a short break before that. Don't go anywhere. Keep watching Jus Punjabi. Welcome back, everyone. I'm Bhupinder and you're watching Jus Punjabi. And in this show, we are talking about all the legal aspects of immigration. And to talk about all that, we have in our studio the attorneys from Bretz & Cohen LLP. We have Kerry and we have Eileen. Welcome back.
Thank you.
Thank you.
So, Kerry, we have received the email. It's about some person who is coming in and out of the country a lot. And they have business here and they're moving a lot from their country to this country. And they want to know, is there any option that they can actually do a business in a better way rather than using B1 and B2?
Oh yeah, and I think what you're talking about is what's commonly called the L visa, and the expert in the office on that really is Eileen. So I'm going to let Eileen tell you about that, as she does a lot of L visas on a regular basis.
Right. Well, if they have a business in their home country, and they could show, it doesn't have to be their business. They could have worked for another company, but as long as they've worked as a manager or an executive in that business for one of the last 3 years, they can be petitioned to come to the United States and work in that affiliated office, or they could open a new office in the United States. This would be an intercompany transferee, also known as the L visa. And the L1A allows for an executive or a manager to be petitioned for by the U.S. company. If it's going to be a startup company, They have a little bit extra on the rules. They'll only give you a 1-year L visa, renewable for a maximum of 7 years. The beautiful thing about an L visa is all the time you spend out of the United States gets added on to that 7-year period because it's 7 years in the United States.
Okay.
It may take someone 10 years to do 7 full years in the United States. They can come over and bring their family. The spouses of an L1A come here and get work authorization, which is very, very important. Most people, when they come as a derivative on a visa, they have the right to live here, maybe go to school, but they usually don't have the right to work. Like an H-1B, their spouses have no legal rights to work. An L1A, their spouses get work authorization and can work for anyone. The children can also come and go to school while in the United States. The L1A is also a great way to, it's kind of like the initial steps before you get your green card. If that same employer wants to petition for you, the beautiful thing about an L1A, that's an EB1 category. And the significance of being in an EB1 category for people from India especially is that there's no waiting list. It's current. For India, everybody has to wait in the second preference category and the third preference category a very long time to get a visa. For an L1A, being an EB1, people from India can just wait the processing time, which is usually 1 year, and get a green card. And again, that includes their spouses and their minor children.
So is it possible that somebody came from India here on tourist visa and they thought that I can actually open up another company here or I open up my business here? Is that possible that they can sponsor themselves?
Well, provided that the businesses are connected, they do the same business, and they're linked up, either an affiliate or a brother-sister corporation. Yes, as the owner of the corporation, you can petition for yourself for the L1A. Again, you need to show that you're a manager or an executive. So it's really important to show the organizational chart. On a new business, you don't have an organizational chart, but you need to show more of a business plan to say how long it's going to take for you to have it up and running where you will be managing more people. The problem with owning the company and petitioning for yourself as an L1A is that then you're unable to petition for a green card. You can't own the company solely and then ultimately get a green card. You can be part owner. You can have a percentage of it, but you shouldn't have a different percentage of the two companies, the US-based company and the company from the home country.
So you're saying that there should be partners in the home country as well as in the US?
And the partnership should be the same percentages.
Ratio.
Same
And
ratio.
if there are two brothers, let's suppose one is in India and one's here, and they're having similar businesses, but no partnership yet, so can they do it for the future?
Yes, absolutely. They can. We had a situation like this where we had two brothers who were partners. One already got his green card. The other one, what they had done is they had different percentages. What they realized is that one brother owned too much at that point. They had a third brother, and now both companies, both in India and in the United States, now own the same amount. The ratio is the same for both companies, for all three brothers, and now it's possible again.
I have a question. So is that the key, that the amount of shares that I own in my Indian company have to be the same amount that I would own in a company I set up in the U.S.?
Yes.
Okay.
Yeah, and you don't want to own more than 51% of the company. If you own more than 51% of the company, again, you would be unable to adjust
Okay,
your
and
status.
I want to understand this better because I really know you're the expert. So I'm in India. I have a B1, B2 tourist visa, and I'm in the jewelry business. I come to New York frequently on my B1, B2, and I say, hey, I want to open up a jewelry business here. So I come to you. You do what? You advise me about how to set up the business and have a business plan, and then that gets submitted to immigration, and I can stay.
Well,
Is it that easy?
possibly. It really depends on how much time you have left on your visa, but you'd have to show that you have the 1 year required time in your home country. And when you want to set it up here, yes, we do have companies that we work with that can do the business plan. You want to have a business plan completed, you need to then find a location. You can't just have a business plan and set up shop. You're going to need to have you know, a location for your store, for your company.
It has to be real.
And it has to, you have to be able to show to immigration that you pay rent, that you, this is where your product is going to be, your merchandise, or whatever your business might be. A lot of times it takes a little bit more time than your visa might have left on it. You may have to go back, but if you come here and it's fairly soon after your entry, it's possible to do it within the 6 months, because there is something called premium processing. So once you have all the legwork done, filing with immigration, you can get a decision within 15 days.
So is there any minimum capital required as well?
No, not for this. This isn't like an EB-5, and it's not like an E2, which India is not eligible for. But what it requires is that the businesses, it shows that you put in the requisite amount for the same type of business. You can't come in over here and put in $600 and expect that the business is going to start and flourish if it's a jewelry business. You have to show that
Yeah, and I think you know, the public policy behind this is to encourage people to come here and open up businesses, or for businesses that are already established here, to have them be able to do, you know, fair trade through the two businesses. But you were raising about the minimum investment is a great topic for another show, and we can talk about that. The EB-5 investor visa, which Eileen also does a lot of, and I think that would be a great topic for another show.
Definitely, we'll talk more about that, but right now it's time to take a short break. So don't go anywhere, keep watching Jus Punjabi. We are in conversation with the attorneys from Bretz & Co. LLP, Kerry and Eileen. Welcome back, I'm Bhupender and you're watching Jus Punjabi, and in this show we are in conversation with the attorneys at law, Kerry Bretz and Eileen Bretz. Welcome to the show again.
Hi, thank you.
And in this segment of the show, we'll talk more about green cards. What if somebody is eligible for a green card, but they have a criminal history, maybe driving while in intoxicated influence, or some fraud or anything? What options do they have? They are still eligible for the green card? Or
I love these questions, because we do a lot of these cases in the office, and I do a lot of lecturing as well to lawyers on how to handle these cases. Well, let's start. First of all, to get a green card, if you're in the U.S., you need to be inspected and admitted, or paroled, or be eligible for a law called 245I. Well, that's a little bit complicated. Let's assume they're eligible. Someone overstayed their visa, they're married to a U.S. citizen, looks like a clean case, but they have an arrest and a conviction for something. So let's go through it. Driving while intoxicated or under the influence of alcohol, which is a common conviction in New York and New Jersey and many parts of the country, will not make somebody ineligible for a green card. It is not an automatic bar. When you are applying for that green card, you have to be what is called not inadmissible. We look to the rules as if you were standing outside of the U.S. coming in. So driving while intoxicated is not going to make you inadmissible. Does that guarantee you the green card? The answer is no, because nobody has a right to permanent residency. It's a discretionary application. Typically 1 DWI, 2 DWIs, you're still probably going to adjust your status. You have 3 or 4, you hurt somebody in one of them, maybe immigration will exercise its discretion to not grant the case. Something a little bit more serious, you mentioned fraud. Let's talk about maybe robbery. It's a whole family, and they're all getting their green card, let's say through a fourth preference. Brother petitioned for his brother, who's married and has a 19-year-old son, all here in the U.S., 245I eligible, ready to get the green card, but the 19-year-old got arrested and convicted of robbery. Wow, pretty serious crime. He's still going to be eligible to get his green card, but he's going to need a waiver. And that waiver is going to require that he have a parent, spouse, or child who would suffer an extreme hardship if he didn't get it. So the way to do that case is to have the mother and father adjust, and then do the child as a derivative and use one of the parents as the qualifying relative. Now this is true with almost all crimes, including very serious ones like sex abuse of a minor, arson, money laundering, any of those crimes it's true with. The bigger problem is controlled substances, marijuana, cocaine. And this also happens a lot with people who have children and might experiment with drugs when they get into the college age, but now they're ready to get their green card. Any controlled substance conviction, with one minor exception, is automatically out. There's no waiver, there's no negotiation, there's nothing. So if you're somebody who has a green card in play and you get arrested for something like this, you need to think seriously about whether you accept a plea to it, even though there may be no penalty. Even though you may pay a fine and not go to jail, it may be enough not to get you a green card. The one minor exception is if you are convicted of simple possession of marijuana of less than 30 grams, a very small amount, one time. And then you can get a waiver, so you still are going to need a waiver. So in terms of getting a green card with criminal history, in most cases, if there's a criminal history, there will be a way to do it if you have a parent, spouse, or child who's a citizen or a resident. If it's a controlled substance, you're out, you're done, there's no way to do it. And by filing the application, you're going to bring yourself to the attention of immigration. When they take your fingerprints, immigration's going to know, and you could be referred for a removal case. So very, very serious. The moral of this story is, and we do a lot of this in this office, if you have a criminal case, that's the time to consult not only a criminal defense lawyer, but an immigration lawyer. What's the best plea to have the least impact on my immigration future in the U.S.?
So does it matter that the crime or like the possession of marijuana or those drugs, it was a long time back and now the person is completely reformed, so is it gonna haunt them still? Also
a great question. The conviction doesn't go away for purposes of immigration if it was 10 years ago or 15 years ago. However, in terms of applying for a waiver, it would be a very nice discretionary factor that it was old, stale, it was one left turn in somebody's life, and they have a lot of rehabilitation, so that's very important. If you are, in New York, adjudicated a youthful offender, and that's usually somebody under 18, that will not count against you. So very often in New York, if somebody's 17, let's say they get a serious crime, they get treated like an adult, but the judge is kind enough to say, okay, we're going to say you're a youthful offender, then it won't count for immigration purposes. And that's pretty true in most of the states. One thing I did want to mention, sometimes people ask me, the petitioner has a criminal history. My husband's a citizen. He just started the petition for me, and now he just got arrested and he's in jail. Can we do it? And the answer is yes, with one big exception. If the petitioner is in jail for a conviction for sex abuse or sex abuse of a minor. A few years ago, the law changed in that regard, and of course the public policy behind that is we don't want people petitioning for spouses and children who have a history of that kind of abuse. So the petitioner pretty much can have a criminal history, can be somebody who's been in and out of jail and still petition, with that one minor exception, as long as it's not related to sex abuse.
Well, definitely. And you were about to say something.
Yeah, even that's called the Adam Walsh Act. If the petitioner has committed a crime that is sex abuse of a minor, they can still petition for them, but now they get interviewed, and the Immigration Service has to decide whether or not they have reformed enough to grant the petition, because the concern here or the public policy is not to put that new beneficiary in harm's way.
Child.
If there's any chance, and it could be the spouse, it doesn't have to be the child, because they do worry about the spouse. Some people are doing mail order brides, and the bride may have no idea what she's getting herself into. So it's really for the protection of the spouse and any children that might come along with that spouse.
Definitely.
And then I had one other thing to add, is that if they do have a conviction and they are ineligible to adjust, they may want to consider what's called post-conviction relief to see if they can correct that crime, maybe get it reduced, and then become eligible for a green card. So all of these things, you really need to go in and speak to an immigration lawyer first, and then you may be directed to a criminal lawyer.
Definitely. Well, as we always say that it's always better not to commit a crime, but if you have, so it's always better to go and consult an attorney at the time of crime for your criminal attorney as well as your immigration lawyer.
That's true. Listen, it's not hard to be arrested in New York City,
Exactly.
even minding your business. So I'm not judging anybody who has that situation, but you're correct. The time to strategize it is the same time you're strategizing your criminal case.
Definitely, and thank you so much for coming to our studio and enlightening so much on different subjects. Thanks a lot.
Thank you.
Thank you.
And thanks a lot for watching us. Keep watching Jus Punjabi. We'll be back. Sat Shri Akal.